Good day. We are Group 3, here to discuss the case of the Bank of the Philippines against Norman and Angelina Yu. Here are the details of the case. So, the parties involved in the case are the Bank of the Philippines as the petitioner and Norman and Angelina Yu as the respondents. In this presentation, we will be focusing on the facts, issues, and the rulings of the case. So, first, here are the facts that follows. Respondents Norman and Angelina Yu, owner of Tuason Trading and Tuason Builders Corporation, borrowed from the Far East Bank and Trust Company amounting to 75 million pesos. Properties such as lands in Legazpi owned by Tuason Trading were executed as a real estate mortgage for collateral. The Yus requested a loan restructuring which was granted by the Bank of the Philippines, resulting in their balance being 33 million pesos 400,000. Due to the difficulties in paying their loan after the restructuring, the Yus asked BPI to release some of the mortgage lands since the total appraised value exceeded the remaining debt, which BPI ignored thereafter. The Yus withheld the payments of the amortization, and due to the non-compliance of the obligation, BPI foreclosed the mortgage properties in Legazpi City and in Fili, Camarines Sur. They sought court action against BPI, and the winning bidder, Magnacraft Development Corporation, for the annulment for the foreclosure sale. The Yus then entered an agreement with the Magnacraft, resulting in the latter's ownership of 3 out of the 10 parcels of land that were auctioned. On October 24, 2003, the Yus filed a new complaint before the Regional Trial Court of Legazpi City against BPI for recovery of excessive penalty charges, attorney's fees, and foreclosure expenses that have been incorporated in the price of auctioned properties. BPI admitted the foreclosure of mortgage properties of 35,055,254 pesos only corresponds to the used debt as of the date of filing of the petition. These are the 3 causes of action against BPI. Excessive penalty charges and interest at 36% per annum compared to 12% per annum fixed by the court, and 14% yearly interest of the principal. BPI imposed a charge of 4,052,046 pesos in attorney's fees, the equivalent of 10% of the principal, interest, and penalty charges. BPI did not provide documents to support its claim for foreclosure expenses of 446,726 pesos and the cost of publication of 518,059 pesos. The RTC granted only a partial summary judgment. It reduced the penalty charge of 36% per annum to 12% per annum until fully paid, but maintained the attorney's fees as reasonable considering that BPI already waived the 1,761,511 pesos that formed part of the attorney's fees. You moved for partial reconsideration for the foreclosure expenses claimed by BPI without support evidence, and questioned how BPI did not dispute the fact that the proceeds of the sales of the properties in Legazpi City have already satisfied the debt. You also sought another reconsideration of the reduction of the penalty charges, claiming that the penalty charges should be deleted due to the violation of Republic Act 3765 or Truth in Lending Act and the allowance of the attorney's fees from 10% to 1%. Next are the issues presented by the petitioner. BPI presents the following issues. Whether or not the case presented no genuine issues of fact such as to warrant a summary judgment by the RTC, and where summary judgment is proper, whether or not the RTC and the CA correctly deleted the penalty charges because BPI's alleged failure to comply with the Truth in Lending Act, correctly reduced the attorney's fees to 1% of the judgment debt, and properly dismissed BPI's counterclaims for moral and exemplary damages, attorney's fees.
Finally, the rulings of the case. The RTC looked at the pleadings, loan agreements, promissory notes, real estate mortgages, foreclosure, and bidding documents to solve the case. Since the parties admitted not only the existence, authenticity, and genuine execution of these documents, but are also uncontested, the trial court did not need to hold a trial for the reception of the evidence of the parties, but rather a summary judgment. The court there said, under Circular 158 of the Central Bank, the lender is required to include the information required by Republic Act 3765 in the contract covering the credit transaction or any other document to be acknowledged and signed by the borrower. In addition, The contract or document shall specify additional charges, if any, which will be collected, in case certain stipulations in the contract are not met by the debtor. In this case, BPI failed to state the penalty charges in the disclosure statement, which are to be disclosed to the borrower before entering into the credits agreement as required by the Act. Even though the promissory notes which are signed by the US contain data including penalty charges required by the Truth in Lending Act, they will still be liable for the act of contravention of the said Act. Due to the authority of the court, to reduce the penalty charges that are unreasonable, considering BPI has collected 2.7 million pesos in interest and penalty charge of 3% per month or 36% per annum on the total amount due, the court affirmed the ruling of RTC ordered to reduce it to 1% per month or 12% per annum. The CA also affirmed the RTC order to reduce the attorney's fee from 10% to 1% for the following reasons. Attorney's fee is not essential to the cost of borrowing but a mere incident of collection. Second, 1% is just inadequate because BPI had already charged foreclosure expenses. Third, attorney's fee of 10% of total amount due is onerous considering the root effort that goes into the extrajudicial foreclosures. Due to all aforementioned reasons, the court denied the petition of BPI and affirmed the Court of Appeals decision. To end, allow us to summarize the whole case. In the agreement of few spouses and the Bank of Philippines, numerous penal clauses were attached to the principal obligation of the use as a penalty such as indemnity of damages and payment of interest in case of the non-compliance of the said obligation. The penal clauses stipulated in the agreement will only be demandable once there is a breach of the obligation. In this case, because the due spouses withheld the payments of amortization, the penal clause of 3% per month or 36 per annum of penalty charge became effective. In this case, the court found out that BPI violated Republic Act 3765 or the Truth in Lending Act when they failed to disclose the penalty charges to be paid by the US in case of non-compliance in the disclosure statement before they both entered the agreement. The court then relied on the ruling of New Sampaguita that the non-disclosure of the penalty charge is non-compliance to the requirement required by the Republic Act 3765. Even though BPI issued a promissory note signed by the YOS that contained the data and penalty charges required, they are still liable for the contravention of the said act. Due to these facts and findings, the court denied the petition of the BPI and affirmed the decision of the Court of Appeals of the restoration of the penalty charge of 12% per annum or 1% per month of the amount due computed from the date of non-payment. That's all for our case digest of Bank of the Philippines Islands PU. Thank you.